think that, oh, we are not gays, but the gays are somewhere else on the other side of the world. And you come and announce this, people were outraged. The government of the day was so much outraged. The Minister of Interior came on radio and said, anybody who dares attend this conference and all that. So that set in motion a discussion about LGBT rights. Are we gays? Are gays here in this country? Have they gone somewhere to Canada, to US, to Europe, and learned these things and brought them here? So the discussion started, and it never stopped, and it continued. Once in a while, it was sporadic, and interestingly, most of the discussions sometimes was based on whether or not LGBT persons were entitled to fundamental human rights. So people will say, no, this is not even a human right at all. So don't start it. It's not a human rights discussion. Now, in 2021, there was a bold step by some group of persons. They called themselves a coalition. So you had traditional leaders, you had religious leaders from different sects, African traditional religion, everybody was in there. And then they came up with a bill titled The Promotion of Proper Human Sexual Rights and Family Values Bill. And it was tabled in Parliament in 2021. Now, legislation goes through a certain process, but immediately the bill was published. The bill itself, the preamble to it, shows that this is a bill, we are going to pass it, and it's a majority supported bill, and whether there are minorities or not, we care less. And so the bill started by saying, oh, we have presidents, past presidents of Ghana, the current president of Ghana, traditional rulers, religious leaders who have condemned sexual minorities or LGBT persons. And therefore, we are bringing this bill to control the activities. And just before then, a conference like this of human rights defenders, and everybody was rounded up. LGBT human rights defenders, everybody was rounded up. So we had a case called O21. My colleague, Julia, was involved in that case. And then also before then, an LGBT office had been opened in the capital, Accra. There were dignitaries from everywhere, ambassadors and all that. And then people said, yes, we said it. People are being indoctrinated by people from the West. And there were calls to arrest them, to prosecute them and all that. So immediately after that, this bill was tabled in Parliament. And the contents of the bill will shock the conscience of any human rights person. Because even for LGBT persons first, the bill criminalized the LGBT identity. It criminalized sexual relations between same-sex persons. It criminalized the activities of academics. So academics cannot talk about LGBT rights in the classroom or anywhere else. And if you are a parent and your child is LGBT, you have to report the person to the police. And academics and human rights defenders whose activities were called promotion of LGBT had even stiffer punishments, up to 10 years, even more than persons who engage in the actual sex. So when this bill was tabled, people in the human rights field were concerned. So people started talking about it. But meanwhile, Ghana had a law on the criminal code, which was inherited from the British colonialists. And so Section 1041B of the Criminal Offences Act criminalized what they call unnatural carnal knowledge. Now, somebody went to court to challenge it in 2021. It was very quiet. Nobody heard about it. Even for those of us in the human rights field, didn't hear about this legal challenge. But in 2023, there was a challenge to the anti-LGBT bill. The bill was still in Parliament, and there was so much engagement, there was so much public discussion about it, because for the first time in Ghana, you had lawyers, academics, professors, everybody coming and saying, this bill is outrageous, you cannot pass it. And so there were several engagements, and the government of the day was seen to be dragging its feet in passing the law, because people were engaging the parliamentarians, and we knew that some parliamentarians were in support of the bill, some of them were against it. So there was constant engagement, and usually bills pass very quickly in Ghana, except for very contentious ones, like the Right Information Act, which will take 10 years to pass. But generally, within a year or two, a law will pass. So if we sit down and do nothing, the bill was going to pass. But then what was the basis to challenge this law? So in 2023, we filed suit in court. So Julia and I, and that's where the positionality comes in. We are lawyers, legal academics, and also human rights advocates. So we represented a client in 2023. We filed suit in the Supreme Court of Ghana, challenging the propriety of the bill on the basis of just one small provision in the Constitution, Article 108, that says that Parliament shall not proceed on a bill which is not coming from government, but if it's a private member's bill, then whether or not the bill imposes a charge on the finances of the state, that should be determined first before the bill goes through. That was not done. And they went on, and we raised those issues in a letter by a client to say, what are you doing? Have you considered this? Because obviously, on the face of it, people were going to be arrested, people were going to be prosecuted, people were going to be put in prison, people were going to be fed. So on the face of the bill, there was a financial imposition on the state, but Parliament had not considered that. And the speaker is that kind of guy, he's a tough guy, says, I am doing my thing here, nobody can intervene. So they went on. So in 2023, June, we filed suit and said that the bill was unconstitutional. And that was the first time anybody had invoked Article 108. Now in 2024, whilst we're still in court, and 2023 was strategic because we said, if this bill was passed, and already people were being subjected to all forms of violence, people were being beaten, all kinds of things were happening to people suspected to be gay. And so 2023, we said, if we don't stop this bill and it passes, then the violations of fundamental human rights will increase. So 2023, we filed suit. We filed an injunction for Parliament to stop. The court initially dismissed our injunction application, but the case was still pending. So Parliament went on. And from that time, they started speeding up the bill. But we knew 2024 was an election year. And by December or January of 2024, the MPs will be all over. And so one strategy was to drag the bill to the wire so that in Ghana, if a parliament sits on a bill, the parliament has 4-year term. If it is not able to complete the processes of enacting a bill, then the bill dies a natural death. So in 2024, sometime in March, another person also filed a legal suit based on the same facts, but on different provisions of the Constitution. This time, this guy was saying that the fundamental human rights provisions of the Constitution will be breached if this law passed. And that was in March. But prior to that, in 2024, February 28, 2024, Parliament passed the bill. And the last leg of it was to submit it to the president for the president to assent it for it to become law. And so we filed another injunction and said this bill cannot go to the president for him to sign. And that one, we saw that the Supreme Court read the ruling in court and said, okay, we'll give our final decision on this when we determine the final outcome of the case. So the bill was not transmitted to the president and it still stayed in Parliament. Can we go on to the next one? Okay, so these are the methodological and theoretical insights which we use. So basically we relied, it's a qualitative research, we relied on our court briefs, judgments, comparative case law, interviewed a few people, we're still collecting data doing that. And then the theoretical lenses are the universalism versus cultural relativism which we use. So this is the Supreme Court of Ghana, this is the room. And this is me and another lawyer. Julia is in another picture. But this was after the court case. And then if you see that the court rejects legal challenges to anti-LGBT bill, and we had to grant an interview. So these were the 3 cases. So the first one is what we were involved, Dr. Amanda Odoi versus Speaker of Parliament. The second one was the guy who joined us almost a year after. And the third one is the one that challenged Section 104 of our Criminal Offences Act of 1960 about that unnatural carnal knowledge provision was unconstitutional. So basically, the court said, okay, the first 2 cases, the court said, listen, we dismiss your cases. And this was in December 2024, after the elections. So we knew that even if we lost, still the bill cannot be passed into law. But the court said, yes, you've lost anyway, and that you should wait for the bill to go to the president to sign for it to become law before you come to Parliament. even though we disagree, the court has the final say. And in this case as well, and that is where you see the court wrestling with the concepts of universalism and cultural relativism. And I'll show you a few slides where you hear the court talking to some judges. And so we can move on to the next slide. Okay, so these are echoes from the court. So the court, in its ruling, made certain statements at portions of the judgment. And the first one, it says, even in today's illusion of universalization of values in the cargo of globalization, whatever that means, state parochiality is not completely abandoned. So the court is resorting to state sovereignty. We are not going to listen to your universal human rights argument. This is Ghana, and we're going to do what suits Ghana. The second one says the impression should not be created that things, controversies, and moral discourses surrounding same-sex relations, and for that matter, unnatural canon knowledge commands a certain universal voice of acceptance. So the court here is rejecting universality and saying that, no, we will not accept that. And when it comes to this particular issue, we won't listen to the voice of universality. And then it goes on to say, it cannot be lightly proposed that Ghana must determine such a fundamental matter without recourse to our peculiar circumstances, molded by our culture, morality, values, traditions, and customs as a people. So here clearly the court is resorting to cultural relativism, elevating the culture and customs over and above constitutional rights. It goes on to say there are many more. It says this court will be vulnerable and risk illegitimacy if it resorts to judge-made constitutional law with little or no cognizable roots in the architecture of our values, customs, and traditions. Our collective conscience, as defined by our traditions, culture, and customs, is imperative in understanding and upholding our constitutional values. So it goes on and on and on. And then, interestingly, the second one, it says, it is difficult to see how the family could be created through a mode of sexual connection that threatens the most naturally ordained roots of conception. As I have found above, the historical, cultural, and social context of our Ghanaian society condemns same-sex relations, and it is this sense of overwhelming disapproval which is manifested in the criminalization of the said conduct. And here the court is talking about the 1960 law, which Britain bequeathed to us, and he's saying that that represents the culture and customs of Ghana. Clearly, the court got this wrong. So what does the judicial reasoning tell us and the implications? So first, the court told us, and prior to this, we reviewed almost every case of the Supreme Court on fundamental human rights. And the court, in its words, had said that human rights is the underlying value of the 1992 Constitution, over and above every other thing. But in this particular case, the court is telling us that no, it prioritizes culture, traditions, and customs over constitutional rights. And then also, it prioritizes procedural conformity. It says that you can't bring this case, wait until the harm has been done before you come here. And then the court also adopts a very restrictive interpretation of the constitutional rights. So in many cases in the Supreme Court of Ghana, the court has even relied on the European Court of Human Rights jurisprudence and all that. 5 minutes? Yes. Cool. Thank you. And also the court contradicts itself, and contrary to previous decisions where it relies on international law, this time it says, no, we are not going to respect Ghana's obligation because Ghana is a member or has signed on to the ICCPR, the International Covenant on Civil and Political Rights, for instance, which says that it is not only violations that have occurred, but also threatened violations of human rights. And the court says, no, we'll not listen to that. So what's the implication for human rights? The court is reluctant, where majority opinion, and in this instance, maybe populism will be the right word, but the majority was pushing that the court should go into a certain direction. And there were times that even members of parliament would go online and mock the judiciary, the chief justice, and all that. And we know that instances, even in election petitions, the court would cite them for contempt, but this time the court was silent. Okay, so we did a comparative analysis of our case with decisions from other African courts, and we find that in almost all the cases, in Malawi, in Uganda, and Kenya, you realize the majoritarian views were very strong. And you hear a court, and sometimes when you read a court judgment, you are wondering whether you are reading something from somebody in a different field other than law, where the court is saying that listen, we are not ready. The majority is not ready to accept this practice, and so we are not going to grant it. And so we see conservative court approaches and progressive, what we call progressive legal stances in South Africa, Botswana, Namibia, Mauritius, where they have decriminalized same-sex conduct through the courts. And what are the factors influencing the rulings? So we look at judicial independence, constitutional language, political environment, and public pressure that shape court decisions. And sometimes when people talk about this, until you are involved in it, you wouldn't know. But 3 days before we went to court, somebody texted me and said, you have lost your case, and it is 7-0. I said, wow. So, but I didn't want to dampen the spirit of the team, and Julia will attest to that. So on the day when we're sitting in court, waiting for the judges to come, then I told her, we've lost the case, and it is 7-0. And she said, well, how did you know? But 3 days before the case, we knew. And then, so we see that Ghana's judicial position aligns with conservative rulings, highlighting the need for judicial reform and human rights alignment. So this is the conclusion page, but I'll just talk about this. So we see that various authors or scholars have done research, and we've done this. We've been involved in one case, others have done 2 other cases, and we see the direction in which the court is going. And you see the language of the majority in Ghana, and you realize that when human rights is mentioned, it is heard or seen as a neo-colonial agenda. But if you look at our own local customs and traditions, and indeed I've done research and published papers that suggest that even before colonialism happened, same-sex relationships existed. But clearly, we are not talking about that. But we see that one of the ways forward is to localize or contextualize human rights framework. So for instance, the South Africans have what we call the Ubuntu. So I see my humanity in you. You see your humanity in me. And we have various wise saying and proverbs in African context, even in the Ghanaian context, that align with the human rights or international human rights framework. And that is what we must adopt as a language of advocacy, of education, and even in the course of litigation. So thank you very much. It's a work in progress, and we're happy to receive comments, suggestions. Thank you.
Wow, that was excellent. Thank you very much. And I'm sure there'll be a lot of questions for you at the end of the panel. So the next panelist will be Josiah Bagayas. He's joining us online from the Philippines. So Josiah, do you want to control your slides yourself, or you want someone doing? Is that it? Okay, so over to you, Josiah.
Hello, good morning, everyone. So it's early in the morning here in the Philippines. I'm apologize for not being able to join you guys in Canada in person for work-related matters, but I'm so thrilled to joining you all online. So my paper, let me share it to you. Hold on. There you go. Okay, so I am going to present this working paper with the title Participatory Governance and Indigenous Peoples' Rights and Progress and Pitfalls in the Philippine Legal Framework. So this working paper is a product of 3 years of teaching constitutional law and human rights law prior to me joining the Foreign Service earlier last June of this year. So there's been a career shift recently. So to start off, the aim of this paper is to critically analyze how the enactment of the Indigenous Peoples' Rights Act in 1997, along with the other statutes and other administrative rules and regulations that concern Indigenous peoples in the Philippines, shape or influence the framework and practice of participatory governance in the country. So as an introduction, Indigenous peoples at a glance, we have these preliminary data from the World Bank and the ILO, indicating that there are at least 476 million people who consider themselves as indigenous, according to 2019 data. And they comprise more than 6% of the global population, but at least a fifth of them live in extreme poverty. And of that number, at least 250 million people who are indigenous live in Asia. And in the Philippines, so we have these photos. On the right side of the screen, the portions that are in blue indicate the areas where most of indigenous Filipinos live. Now, I need to distinguish because there's a legal definition of what an indigenous person or indigenous people is, at least in the Philippines context. So we could see here that according to the 2020 Philippine census, indigenous peoples comprise at least 7.5% of the population, but there's another finding that at least 1.5% of the Philippine population are both indigenous peoples and also part of Muslim tribes. And another 5% are part of Muslim tribes. And here in the table, we could see that there is a tabulation of the numbers of indigenous peoples from the Subanen or the Subanon, numbering at least more than 750,000, and down to the Iranon or the Iranian, numbering more than 300,000. So this is just a snapshot of the numbers and the places where indigenous peoples in the Philippines reside. Now, the legal framework on indigenous peoples, of course, there is an interaction between international law on one hand and the Philippine domestic law on the other. We have the International Bill of Rights as the framework that where indigenous rights are hinged on. These are the UDHR, of course, the ICCPR, ICE, CSR, and we have the UN DRIP, or the Declaration on the Rights of Indigenous Peoples, that was promulgated in 2007. But of course, this is non-binding, and of course, the ILO Convention 169. Now, in the Philippines, we start off with the 1987 Philippine Constitution, where it provides for, as a state policy, support for indigenous peoples. And because of that particular provision, the IPRA, or the Indigenous Peoples' Rights Act, was enacted in 1997, 10 years after the current Philippine Constitution was promulgated. And along with it are a number of Republic Acts and legislative measures that were enacted by Philippine Congress to add on other areas or spheres where IPRA just provided for abstractions. And also to implement these measures, we have admin rules and regulations. And we would also look at certain Supreme Court jurisprudence that touch on the matter. So this is like a snapshot of what the legal framework on indigenous peoples in the Philippines and abroad. And conceptually, in connection with the workshop, I indicate that this is the framework that participatory governance on one hand is a subset of democracy. Of course, there are a lot of theories of democracy, one of which is participatory democracy. And from that strand of democratic theory, the literature now, we have participatory governance, which I will define later on. And on the other hand, we have indigenous rights, which is also part and parcel of human rights as a whole. And as a research methodology, I used process tracing as a methodological tool and refracted through the lens of social legal approach. Okay, so here, as I mentioned, participatory governance is a marriage of two concepts: participation on one hand and governance on the other. And to define it, this is from Ansel and Gash. Participatory governance, they define it as the collaborative process whereby citizens and stakeholders actively engage in shaping public policies and decisions. And another definition by Fung and Wright, they define participatory governance as the deepening of democratic engagement through the participation of citizens in the processes of governance with the state. So here we have other definitions of participatory governance as contained in the paper, but I focus these two definitions to highlight the elements of collaboration and active and democratic engagement by citizens with state processes. And indigenous rights, on the other hand, these are considered as collective or group rights, as opposed to the dominant Western conception of rights, which state that individuals are primarily the holders of rights. This strand, mostly from non-Western thought, that indigenous rights are actually held by a group or a collectivity. So one of the definition of which is that these are both legal and extra legal rights conferred on those considered indigenous because they have been the subject of the jurisdiction of sovereign nation states that they did not institute, and this is a consequence of colonization, subjugation, and other circumstances. Now we go to the meat of the paper. So we start off with the IPRA, or the Republic Act number 8371. The IPRA, it has or it provides a definition of indigenous peoples. So in international law, specifically in UN DRIP, there is no standard definition of what an indigenous person is. But allow me to read to you how IPRA defines indigenous peoples. So under the law, it defines indigenous peoples as a group of people or homogeneous societies identified by self-ascription and ascription by others who have continuously lived as organized community on communally bounded and defined territory, and who have, under claims of ownership since time immemorial, occupied, possessed customs, traditions, and other distinctive cultural traits, or who have, through resistance to political, social, and cultural inroads of colonization, non-indigenous religions and culture, and thus became historically differentiated from the majority of Filipinos. So to contextualize, I myself am not considered as an indigenous person or part of an indigenous people through this definition. And as I read to you, there's a lot to unpack there. There's a lot of elements by which or before a person or a group of like an ethnic group be considered as indigenous. So IPRA provides for at least 4 bundles of rights as shown here on the screen. So we start off with the social justice and human rights. Then we have the rights to ancestral domain and lands, right to cultural integrity, and right to self-governance and empowerment. So we would focus our attention on the last 3. And because the social justice and human rights is an all-encompassing bundle of rights that on which all the other rights are hinged on. So we start off with the first one and how IPRA actually codified or at least empowered indigenous peoples to participate in the governance processes in the Philippines. So the right to ancestral domains and lands has a long history in the Philippines, especially also in other jurisdictions where there is a history of colonization. It all began with the Jura Regale Doctrine, or the Regalian Doctrine, that all lands of the public domain belong to the crown, specifically to the Spanish crown, and thus belong to the state. And this doctrine is codified in the succeeding constitutions of the Philippines that began from the Philippine Bill of 1902 and down to the current constitution that was enacted in 1987. But as early as 1909, there is a specific case decided by the US Supreme Court that involved a certain tribes person from the Igorot tribe, where the concept of native title was actually recognized. So this native title states, or it's all about ownership by virtue of a claim since time immemorial, and it is independent of any grant from the Spanish crown. And from this 1909 case, this is the Carino versus Insular Government case, the concept of indigenous ownership now has been codified by IPRA. So under the current law, this indigenous concept of ownership is defined as the pre-conquest rights to land and domains held under a claim of private ownership as far back as memory reaches. So there is an emphasis on since time immemorial and as far back as memory reaches. But of course, these are not rights. This right in particular is not self-executory, such that it is it should be harmonized with the current property regime in the Philippines. So um, as to make this right more substantial, rules have been promulgated as well, specifically on the delineation and recognition of ancestral domains and ancestral lands. So these rules are pretty recent. These were just enacted in 2020 to govern the process by which Indigenous peoples would claim would apply for titles over their ancestral lands and domains. Now, there is also a difference between ancestral domains and ancestral lands. Ancestral domains are larger, such that they don't only pertain to lands, but also to the natural resources and inland waters and other areas that it covers. Now, going back to the rules on delineation, one aspect in that where participatory governance comes into play is that the representatives of indigenous peoples would self-delineate, meaning they would be the ones who would tell the boundaries of the ancestral domains or ancestral lands that they are applying for a title. So this takes place such that they would use traditional boundaries, or they would also present other evidence that could be that would prove their claims. That could be in the form of testimonial or documentary, as well as other like customary law as well. And that these rules also highlight that customary law is there is a primacy of customary law in the resolution of conflicts in delineating the boundaries of ancestral domains and lands. Now, aside from that, there is also a set of guidelines on the formulation of ancestral domain, sustainable development and protection plans. So this is a comprehensive, at least a 5-year plan where key leaders of indigenous peoples would participate in. Hold on, 5 minutes remaining. I'm so sorry. Okay, so let me just. All right, but one of the pitfalls is that only a third of targeted ancestral domains were issued with certificates of title because of insufficient resources and expertise in the delineation process. And that there's also a specific case by the Supreme Court ruled 2 years ago that Baguio City, which is the commercial center of one of the areas where there's a lot of indigenous peoples, these are exempt from the coverage of IBRA. Now, on the right to cultural integrity, one of the stark provisions that highlight participatory governance is that for instance, the National Cultural Heritage Act was enacted as well in tandem with this right, and another set of guidelines was enacted so that indigenous knowledge systems and practices, as well as customary laws, any research and documentation that involve these requires the full participation of indigenous peoples in all stages of research. And one more thing is that the general law on intellectual property does not specify or does not provide for provisions on intellectual property rights of indigenous peoples. That's why a certain joint administrative order between the Intellectual Property Office of the Philippines and the National Commission on Indigenous Peoples, they promulgated rules such that indigenous peoples would have the right to own, control, and develop and protect their IKSPs. And there's a specific controversial case in the Philippines that involved a research team from Sweden. So this is from Uppsala University. Dr. Lorena and his team, they collected more than 2 million genotypes from 1,028 members of indigenous peoples, and it was found out later on that the free, prior, and informed consent of these individuals was not complied with, and ethical clearances from the Philippine Health Research Ethics Board was not obtained, and this is because of regulatory capacity of implementing agencies are inadequate, and as well as with the asymmetrical relations between researchers and their research subjects. So we also have, under the right to cultural integrity, these provisions on education, such that the formal schooling would be localized and indigenized to include the worldviews, as well as to preserve the cultures of indigenous peoples, towards the end of eliminating discrimination on the basis of cultural identity. But one of the things that happened just last year was that, for instance, the mother tongue-based multilingual education policy that provides that regional languages would be the medium of instruction in schools. This policy has shifted and reverted to Filipino and English starting this school year. Okay, now to the last part, as to the right to self-governance and empowerment. There is a specific guidelines that provide for the mandatory representation of indigenous peoples in local legislative councils and policy-making bodies. So as of 2020, there have been more than 4,000 IPMRs in these local councils, but there is a finding that at least a number of local government units rejected the IPMRs in their jurisdictions because of lack of budget, for instance, and as well as they are not politically aligned with these representatives. And then the establishment of indigenous peoples organizations has also been has expanded the role of IPs in civil society, and broad coalitions such as Katribu and Panaghiusa, for instance, were established. Okay, so let me just go to the concluding points. Now, the Philippine legal framework substantially espouses the fundamentals of participatory governance because these deliberately included indigenous peoples in the decision-making and policy-shaping processes. But I aver that the full realization of indigenous rights is never insulated from political dynamics, both at the national and the local levels, such that these laws, as well as the rules, are always subject to change, and they are not immutable. And there are also concerns there are concerns of IPs that compete with other sectoral interests, such that prioritization when it comes to legislation and lobbying would also face competition with other sectoral groups. And they also note that there is a lack of coordination among government agencies, and this would lead to policy incoherence for one, and then also gaps in service delivery and duplication of efforts. Ultimately, that will lead to the wastage of public resources. But in the end, the enactment of VIPRA, along with the statutes, actually filled a legal vacuum that without them, there would be more pitfalls than progress. But the codification and operationalization of indigenous rights are but means towards the end of attaining participatory governance. So with that, I end my presentation. I would be inviting questions by the end of the panel. Thank you.
Thank you, Josiah. I never knew this moment would come. I was hoping you'd just go on and on. Okay, thank you very much. Please bear with me. I have a cold, so I might have to relieve myself. Then. I have 20 minutes, right?
Yes.
Okay, thank you. So thank you to the first two panelists. Hello, everybody, once again. My name is Nnamdi, and I'm a doctoral candidate in history here at McMaster. I've communicated with most of you in the last few months and weeks and days. So I haven't said hello to you already in the course of the day. Hello now, and I hope we get to catch up. I'm really excited to be on this panel, although I don't know who thought it was a good idea to put me in a group with lawyers. I'll try my best. So my paper is titled Digital Participation and the Protection of Civil and Political Rights. And in keeping with the conference theme of thinking about how we collectively move our world towards an inclusive and participatory human rights agenda, I want to use this paper to talk about majority rule, minority rights, and democracy from the perspective of digital participation. And I believe that as we engage some of the opportunities and challenges that lie at this intersection of digital communications and civil and political rights, of course, you recognize things that you're already familiar with, either from your work or other people's work. But I'm also hoping that maybe there might be some new ideas that you'll find interesting enough to question or make contributions about. So the main concept of this paper is the fundamental human right that guarantees freedom of expression. And this right is provided for in Article 19 of the UDHR, as well as the ICCPR, which has been spoken about by some other speakers, as well as many other instruments of the United Nations. And at regional, national levels, we have provisions made for freedom of expression across many jurisdictions. But of course, we all know from what we observe daily that this right is not really guaranteed. Even where it is provided for, we see violations. And sometimes it's in the way it is interpreted or the way it is implemented in ways that leave us people confused. So what does freedom of expression really mean in our world where that expression is increasingly mediated through digital communication platforms? There are many studies that have examined the meaning of digital communications with respect to freedom of expression. And in fact, Jorgensen has suggested that it is the most debated of all human rights. Sorry, I know you said it's the right to life. But he was talking about this in the context of global communications and media policy. Because the freedom of expression protects other liberties, right? Like free access to information and how it's disseminated through different media as well as across frontiers. Yuval Noah Harari has also asserted that freedom of expression is a central aspect of democracy, which is why I think it's part of why I think it's important, and it serves as a self-correction mechanism. So if people are not happy with their government, for example, they don't need to wait until the polls to vote them out. They can express themselves and let the government know we're not happy. Freedom of expression is important. And as democracy is about majority rule in its, in the best sense we can think about it, what he argues is that everyone's best interests are served when the majority, the people who control the democracy, protect this freedom of expression for everybody, particularly for the minority, which they could be during the next round. But as we all know, that's not part of what we see in today's world. And whereas the burden of protecting free expression is placed on governments, a recent turn in the historiography of digital communications has engaged how this communications is managed through private governance systems. For example, Jorgensen and Zuleta argue in this 2020 paper on private governance of freedom of expression on social media, using Denmark as a case study, that human rights safeguards are not included in the way social platforms govern freedom of expression, largely because the EU policies legitimize and encourage the way these platforms operate. And in this 2023 article on the United Kingdom's online safety regime, Newdet argues that there is a challenge of regulatory capacity capture. Essentially, regulatory bodies are struggling to, regulate how online platforms regulate freedom of expression. And then in this comparative analysis of the online compliance and enforcement regimes in the UK and the EU, law highlights one of the challenges of human rights generally, universality versus particularity, pointing out how differences in the way it is implemented, locally complicates this question of how is it a universal human right. So all these conversations about digital participation and the protection of civil and political rights go beyond the advanced democracies of the world. We had a paper speaking about the use of AI in the global south in India. And we sometimes take it for granted, but it is actually also challenged in places where we supposedly take it that there's strong freedom of expression. And so what I want to do in this paper is to talk about some of the opportunities that exist when we consider rights-based approaches as a way to ensure we have freedom of expression online. So given the apprehension that exists in human rights circles about the risks that are posed to online expression or freedom of expression online, certain questions guided this paper. For example, I was curious to know if rights-based approaches can amplify marginalized voices in digital spaces. From my preamble, you can probably answer that yes, it's possible, even if there are risks. I also wondered if the online moderation that goes on currently can be suited for the purpose of promoting freedom of expression. Again, I believe that that is possible, even though there are risks. And finally, I was curious about if our steady transition to digital dependency, because that's what we're doing, slow but steady in some places, fast-paced, but we're steadily moving into a digital world. Can this thing encompass protections for free expression? Well, let you wait until the end of the paper to determine for yourself. So there's a tendency to regard limitations on free expression as a problem in less developed democracies. I've spoken about that, but it's really challenged in so many other parts of the world. And I think there's room for engagement here. So with respect to democracy and freedom of expression, the argument has been made that despite significant progress in defining international frameworks for human rights standards, as well as mechanisms for ongoing monitoring of their realization, rights-based approaches that provide a normative basis for developing communication and media policies have not been adopted. In the United States, for example, print media enjoys greater freedoms under the First Amendment than broadcast media, which face greater regulatory hurdles in terms of the requirements that govern their operations, as well as the content they can carry. So with print, for example, you don't require a license to publish a newspaper under the First Amendment, but with broadcast, you need a license. So that's already a limitation. You can't just get up and open a radio station, so to speak. And then there are reasons for that, around it's a limited resource, bandwidth, we can't allocate it to everybody. So we have to figure out who we keep it to. I don't want to get into all that detail now, but you just can't open a radio station. And even if you have a radio station, there are rules you must face or follow, which you don't necessarily have to do if it was a print platform. And what the telecommunications revolution has done is to complicate that problem, because with the internet, for example, anyone can start a podcast and broadcast to a wide audience. So digital platforms have created complications for mass media and convergences that existing regulations did not envision, and they are, at least in many cases, not able to provide for. So within the context of democratic participation, the concerns that abound over freedom of expression and how it's exercised in our world, where communication is increasingly mediated through digital platforms, is something worth thinking about. Now, when the internet launched, it was hailed as a democratizing force in relation to the freedom of expression. I was talking about setting up a radio station. It's going to cost you money to open a newspaper or a radio station. But with the internet, all you need is a connection, and then you can communicate, right? So for one, it enhanced individual abilities to seek and share information beyond the capacity of traditional media. And then social media came and expanded the online space in all the ways that we're familiar with. But then, not long after, enthusiasm over the role of digital communication waned because of the harmful use to which it was put. We're all familiar with this. You may have experienced vicious online attacks if you have a social media account. I'm not trying to say that people being overcritical of your opinion is new or came about because of social media. I mean, academics will tell you that peer review can be brutal and even demoralizing, right? They'll tell you that. But I mean, what you get there doesn't compare to those intellectual conversations you get on Twitter where people think they know and they're just so rude, and there are so many other kinds of online harms, such as the spread of harmful content that could incite violence or discrimination, or spreading bad information and propaganda. So all of these have led to the need for censorship. We all somewhat agree that there's a need for censorship. What we don't seem to be able to agree on is how this censorship should be done. And, part of the reason is that censoring of content online actually limits freedom of expression, even if we don't think about it in those terms. So few people will argue about the need for some level of censorship, like I've pointed out, but there are also risks over the concerns of over-regulation, that is disproportionate to the harm that it is seeking to correct. I should state here that freedom of expression is not absolute. In fact, Article 19 of the ICCPR provides that freedom of expression may be restricted if it is provided by law or as a necessity with respect to the rights of others, the reputation of others, and for the protection of national security. For example, public order, health, morals, etc. In other words, there are instances where censorship is useful, or required, but our experience shows that freedom of expression is frequently hindered by other factors like populism, which was mentioned earlier, or strongman politics. Nobody doesn't want to talk. So regardless of what your view is, digital censorship is quite widespread. One recent study says that since 2016, more than 100 governments have implemented a variety of regulations like content controls, data protection, and all in a bid to curb the harms that are perpetuated by people or institutions or even the state via internet platforms. And even though regulations are instituted by governments, the online content regulation is mostly done by companies. So the governments create the laws, but the companies enforce them, and this is where there's a problem, because many of these companies are driven by private interests, not public profit motives and what have you. And so in engaging in censorship, they don't necessarily adopt a rights-based approach. In the United Kingdom, for example, the Online Safety Act was passed, in 2023, and the European Union passed the Digital Services Act in 2024. The broad thrust of these acts is to regulate digital content and systems as well as processes. But these regulations have come under scrutiny. So one scholar has said, for example, that with the Online Safety Act, those kind of regulations, the content regulation has moved from adjudicative models that establish liability for free expression to responsibility models that give the platforms power to shape communications. Let me explain what that means. Before this online system, if you were going to publish something libelous, whatever, what will stop you from doing it is the fear of a court case. For example, you don't want to get sued, but now companies that have these platforms are managing, they can determine if your content makes sense or not and pull it down or suspend your account. And so that has moved the way content or free expression is regulated. But what this has done is that it's not based on human rights necessarily. When you sign on a platform, they're likely going to ask you to agree to some terms and conditions. And so if they pull down your content or shut down your account, it's probably because you violated something, maybe somebody's IP rights or somebody's whatever rights, or maybe even engage in something criminal. But it's the contract law that governs that your engagement with that platform that determines even if you actually violate somebody else's rights. It's not that human rights perspective that has made you lose that content or post or whatever. Is because of contract law. So it's not a rights-based approach, and essentially what this does, according to one scholar, is that human rights now through these platforms are not being protected as something that is inherent to human beings as autonomous beings, but as something that is given to you. So it is a right that the platforms allow you to have, that you have, not what is inherent to you as human rights based approaches would recommend. Okay, so let me move quickly because I know time is moving. I want to talk about artificial intelligence. Online companies increasingly rely on artificial intelligence models for content regulation, and this complicates the problem we were spoken about earlier. So although the violations on freedom of expression in existing systems affects all people, the challenge is more acute for vulnerable groups, as AI can reflect real life inequalities. So when you guys were speaking, you were really speaking to me when you said the models being developed in India are focusing on the majority languages. So it means the minority languages still have some catching up to do. So they can reflect real life inequalities. And what that would mean is any benefits that AI would offer to society may not accrue to them. But then the flip side of that is that they could also be in harm's way if those systems start to perpetuate harmful content. I'll discuss this shortly. So similar problems may be seen even in places with supposedly strong regulations. I mentioned that earlier. For minority groups, for example, AI regulation can still flag content that is legal, and users are left without satisfactory means to contest these decisions. If Twitter or X has ever suspended your account, you might know how frustrating it is. You posted something that someone reported, and you feel like you take it or leave it basis. It's either you agree to pull down your content or your account stays suspended. You could decide to wait for the adjudicatory process. For example, I have an account that's been off since the 2023 elections in Nigeria, and I feel so passionate about that post, and I'm not taking it down. But the adjudication is still going on, so it can be very frustrating. Now, in order to avoid censorship, then what people will do is to try and self-regulate themselves on what they are posting. So in a way, the objective of avoiding regulation is making you regulate yourself, and so your expression is being limited in a sense online. So Meta, which owns Facebook, commissioned an independent review of its AI content moderation systems in 2022 and found that the systems were designed and better equipped to identify violations by Arabic speakers compared to Hebrew speakers. And this led to greater penalization of people who were posting content in Arabic. on the platform. So what Meta did in response to that review was to make a commitment that it would establish algorithms for tracking violations in Hebrew, which it didn't have before, even though it had one for Arabic. But it also went further to commit to creating new algorithms that were proficient in understanding Arabic dialects. And so, I mean, they're taking positive steps to establish equity in censorship, if you like, but they also took its moderation of Arabic content a step further. And so in establishing legislation that empowers internet companies to regulate information that flows through their platforms, states may put forward the notion that they are upholding the duty to protect freedom of expression. But researchers have argued that states really lack the capacity to regulate how private companies censor online content. That is because they lack information on how the platform acts and the algorithm. This was raised in the paper earlier on AI. They are also substantially behind in terms of the resources they can commit to monitoring of platforms. There are so many needs for the state to meet, right? And then, interestingly, platforms wield a lot of political and social influence that tends to undermine or diminish what may seem to be the authority of the state. So the incapacity of the state to keep pace and evolve with technological and cultural changes in media and communication networks of the digital age has been described as regulatory hangover. And even where states accept the responsibilities to guarantee users' rights, the balance of power still lies with the platforms who can determine who speaks and when. Okay, so almost there. This image shows a tweet by former President Donald Trump on a screen during a House Select Committee hearing to investigate the January 6th attack on the US Capitol. And I'm using the image to underscore the point that beyond the harm that can come to individuals and minority groups through the spread of content like hate speech or digital digital platforms have been used to mobilize against states or to plan large-scale harm. The January 6, 2021 riots are an example of how online campaigns of disinformation and misinformation, fake news, conspiracy theories can result in attempts to stifle expression offline and even cause harm to those with different political opinions. We can take another example from Myanmar. So during the democratizations that happened there in the 2010s, Buddhists in the country subjected the Rohingya Muslim minority to several waves of violence. I know you said Buddhists don't always, but one example. They subjected the Rohingya minority population to severe, violent attacks. And this was driven by Facebook's algorithm, really. That's what an independent inquiry found. But I think the point to make here is that AI has the power to not only censor people in ways that we don't understand, but even also to promote content, because it's about what you see, what it thinks is popular, it keeps pushing it, even though steps are now being taken to fix some of those kind of things. So this kind of incidents highlights the need for censorship and the risks that language models like AI can pose. But relying on censorship to check excesses like this also raises questions about surveillance. So if we're going to start checking, what people are posting online to prevent, all these kind of things, what people are posting online, we could also be creating this surveillance state. In China, for example, the government upholds the concept of internet sovereignty, which holds that the national government can assert authority over online content and providers. And from the 2010s, several legislative measures were taken to enable the state's capacity to engage in state surveillance. For example, in December 2012, persons who wanted to use social media were required to register with their real name, no fake names, and the providers were mandated to report offensive posts. And then the next year, the Supreme People's Court authorized jail terms for posts that spread rumors and defamation. And so over time, content regulation measures have combined with a variety of other technological developments in China, things like facial recognition, voice recognition, and artificial intelligence and big data to create this big brother state where the government can control speech and predict protests. And all of this entrenches a system for limiting online expression that can challenge the authority of the government there. But China is not alone, it's just a very popular example. And there are many other nations who use similar types of control to deliver a different reality for their people. So in conclusion, if we think about the volume of information that is exchanged over digital platforms. Government cannot take over the task of content regulation. So that's not what I'm pushing for here. It would not be efficient for government to commit its time or resources to this, actually. Even legal systems, the courts cannot take over all the libels and wrong posts or whatever it is that we find online. So content regulation has its benefits. And artificial intelligence can be a plus in upholding freedom of expression if rights-based approaches are adopted. That means for me, strong oversight and financial commitment is required from the states. The opaque systems of artificial intelligence cannot be allowed to proceed unchecked. The state needs to invest in supervising what's going on, research and design of its own systems that can audit or appraise what artificial intelligence is doing, laws to limit what it can do, and then also engage in widespread education of people so that they can understand what kind of options or recourse is available to them. I also think the human rights and scholarly community, those of us in this room, need to remain vigilant in studying how new technologies pose a risk to free expression and human communication that is increasingly mediated through digital platforms. So thank you very much for your attention. Okay, so questions. We'll move to that big slide. Okay, so questions. Anybody has questions for the panel? I have one. So I want to ask Ernest a question, and maybe it's a comment as well. I'm curious to know if there were influences from other African communities on how Ghanaians responded to this issue, the legal regime that was trying to be introduced to suppress sexual minorities. We know Uganda is popular all over the world for its state-driven measures. Nigeria has its own laws as well. So you had mentioned that people were saying these things happen there, not here. But you have people also saying, well, even across the rest of Africa, this is not accepted, this kind of sexual behavior is not accepted. Did that in any way influence how people thought about it? And I'm also curious to know about the international influences as well. So the Obama government, for example, was very vocal in critiquing African countries that had those kind of laws. And I think that's one of the reasons it's not popular in Africa, even though it's black. People felt those ideas went against their religious beliefs. And on the other hand, many Africans see Trump as a good Christian because of his upholding these values of oppressing sexual minorities. So do you have any sense of, how these two influences might have played on local perceptions or responses to this law, and do you have any influence on proceeding?
Okay, thank you very much. This is a very loaded question, very interesting one, but I'll try. So the influence from Africa, I'll start from your country, Nigeria.
Yes.
So Nigeria influenced us a lot.
Mm-hmm.
So you passed the Same-Sex Marriage Act.
Yes.
And then everybody said, oh, it is possible to pass these laws. Then you see Uganda and other examples from Africa. So our politicians always refer to African countries as a source. And then we know also that there is a global push to criminalize LGBT identities and pass laws in Africa. And CNN has done a research that shows that more than $200 million have been pumped into that project. And so you can see that there is a hand pushing these things. And so, yes, we had influences from Africa. And the movement also that the late president of Zimbabwe, Mr. Mugabe, stood on that UN podium to say that in Africa, we are not gays. That resonated all around Africa. So people started thinking, oh, so we are not gays. He has said it for us. And so who are the gays? So that also influenced the law. But also the international influence, I think that is positive and negative. So when Tony Blair and then other world leaders said, oh, we're going to tie aid to LGBT rights. And then you see the UN chief, Ban Ki-moon, going to Malawi when the Malawi gay wedding trial and the two guys were jailed in Malawi, if you remember, 2009. So people were wondering, why did you come here? Only because of gay people. But we are hungry, there's poverty, you didn't come. So that also stoked some kind of anger. Yeah. And in Ghana also, the international influence, for instance, just prior to the bill, before the bill was laid in Parliament, there was I have known LGBT human rights defenders in Ghana for more than 2 decades. And they are on their quiet. They work, and there was a time that even one person that I knew worked in that space, was driving a car which was leaving office of the president. And I'm sure the office of the president didn't even know, because he was working in HIV and human rights and all that. But that they were also working in that field, in the LGBT field as well. But then when the office was open in Accra, and then you saw the ambassador of this country, this foreign country, ambassador of this other country, and then they said, oh, but we said it. They are the ones pushing it. As if people in Ghana don't have agents. And the records show that this has been there even before independence. So it's not somebody pushing it. And so that's the negative side. The positive side also is that when, am I on record? Yes. Some of the things I may not be able to say on record, but you have support also from international organizations and international persons. But they don't want to come into the limelight. They don't want to be mentioned, because this case happens and then everybody's, wow, if this bill passes, we don't know, they are coming for gays, you don't talk. The next thing is that they will finish and they will come for you as well. So somebody had to talk, and people had to support us, give us words of encouragement, meetings, and all that. But then they didn't want to come out in the open, because those of you who follow the news, remember when Kamala Harris, Vice President, then went to Ghana, the Speaker of Parliament, quarrel with an empty room. Kamala Harris didn't say anything about LGBT rights, but the Speaker went to Parliament the following week and started lambasting her. You can't teach us what is human rights. You can't teach us how to govern. Meanwhile, she didn't come to talk about it. There was a harmless question by somebody. She avoided that topic, actually, and it was good for everybody. And somebody asked her about the question and said, throughout my life as a lawyer, it's been human rights, etc. But the Speaker took issue with that. And the Speaker of Parliament actually has been on record to say, we will push this agenda. Usually the speakers are neutral and they don't get involved. So positive and negative influence. And I think Ghana might also have influenced other countries, maybe positively or negatively, because I was working on a project, went to Malawi, and people said, oh, you're from Ghana. You guys did well to stop this bill. Because if your bill has passed, the next thing we were also going to pass. So they were waiting for your bill to go through, and then it will also start in Malawi. So it's positive and negative.
Thank you. Excellent response.
Yeah.
Any questions?
Can I ask a follow-up
Yes.
also to Ernest? So in light of this, I'm interested to know if you could tell us a little bit more detail about how it is that you use charter provisions in your challenge.
Okay. So thanks very much.
This is obviously the original instrument that was
Yeah.
initiated by the organization for Africa.
Exactly. So the African Charter, one curious provision that is missing from it is the right to privacy. So you cannot talk about privacy in terms of the African Charter. But one key provision is the right to dignity. And if you look at the cases from Botswana, South Africa, Mauritius, and all that, the courts have relied on the right to dignity to decriminalize same-sex relations. And so using the African Charter, in fact, the opposite is also the case. The other side also uses the African Charter. You see, the African Charter talks about the family and all that in Article 18 of the African Charter. So they use that. And even in the third case that I discussed, the judge used that. And so look at the African Charter. But I've written an article to debunk that notion that because of family rights and all that, because our friend here talked about indigenous rights. The African Charter didn't have that, but the African Commission has extended the rights in the African Charter to cover indigenous people. So we think that the African Charter, even though it doesn't mention sexual orientation or sexual minorities expressly in the African Charter, it still can be extended to cover such like that.
Excellent. Any other questions? Let's see.
I'm interested for all of your perspectives, like what are the circumstances under which minority rights are more likely to be successfully protected?
Okay, thank you. So if I get the question, how could minority rights be successfully protected?
Yeah, I mean, for example, Ernest, in your presentation
Yes.
specifically in the comparative slide, you had some different variables. So I'm curious about what was the effect of judicial independence and public opinion, and for Josiah and for Nnamdi as well. Like what do you see as key factors for why in some instances we see more successful promotion and protection of minority rights than others now?
That's a tough one. Yeah. But I remember that prior to our case, our Attorney General went to the UN, presented Ghana's human rights record, and talked about protection of minority rights. That Ghana does protect minority rights. But on top of my head, I'm struggling to remember any case by the Supreme Court that has touched on minority rights. But from the jurisprudence of the Supreme Court, it is possible. Except that with this case, the Supreme Court was railroaded by the majority to say, we can't have this. You can't talk about this. And you see, you also talked about judicial independence. You see, the judge that made most of the comments there is still in the public light. Before he delivered this judgment, there was a criminal case against his cousin. And he called the Attorney General and his cousin to a meeting in the house at dawn. So the matter was out there in the public. We could hear the recording. And then the Attorney General talking to the accused person. And this is a judge at the center. He had to redeem his image. So he went to the court, said these things, and the public was happy that he said this. So in a way, in Africa, I can say some things on the record, but judicial independence, to a very large extent, sometimes it's missing. And in our case in Ghana, what I've seen, what I've heard, and what I can testify to suggests that it is questionable. And if you have followed the news, our Chief Justice has just been removed from office. And some of the charges against was bad with the government, which was voted out of power in 2024 December. So on paper, it is possible to defend minority rights and be successful. But in practice, when you go to the court, the way they even look at you, and that courtroom I showed you is a torture chamber. The way they will change you left, right, and center, the way they will even look at, so you get to restrain the speaker. Say yes, no. And it's not an easy thing, but it is possible.
So I think there is opportunity for groups outside of government to try to promote the protection of minority rights, even though it's the government that has this primary responsibility. So groups like academia, human rights groups can continue to speak about this challenge. We cannot lay down our tools and say because something is happening or it feels like you're throwing a drop of water in the ocean, it doesn't make a difference. We have to keep talking about it. The press also has a role to play. All of these are independent institutions that can help to protect minority rights. And that is why people who are like dictators or populists want to attack these other independent sources of authority because they know that they can undermine whatever they're trying to achieve. So they want to delegitimize academia, they want to delegitimize the media. These are spaces where those conversations can go on outside of government influence and keep the fire alive. So I think those are opportunities for minority rights. Josiah, you want to try? You want to respond to the question?
Yes, sure. So thanks for the question. So if I got it right, the question goes into or asking about the circumstances under which minority rights are more likely to be protected. So in my paper, I wasn't able to present in full, but there's a part there where it was stated that members of indigenous peoples and communities have been subject to cases of red tagging or red baiting. So these are acts that they have been publicly labeled or associated with individuals or organizations with leftist ideologies or with subversion or communism. And because of these acts of red tagging, most likely members of indigenous peoples have been subject to intimidation, violence, and death. And there's actually a series of attacks that happened around 2015 and to 2017 during the term of former President Duterte. Some were in Mindanao among Manobo tribes. So they have been under the guise of counterinsurgency operations against communist rebels. These tribes have been subject to attacks because they have been red tagged, meaning they have been labeled as part of these communist rebels. So I do think that when it comes to circumstances that minority rights are more likely to be protected, I aver that courts play a central role in that. In particular to this case, 2 years ago, the Philippine Supreme Court actually ruled that the protective writ of amparo, so that's a special writ that provides protection to those individuals whose rights to security or liberty, especially in cases of extrajudicial killings and enforced disappearances, are affected. Now, the Supreme Court here ruled that this protective writ applies to cases of red tagging, such that, according to the Supreme Court's logic, red tagging is actually a precursor to enforce these disappearances as well as extrajudicial killings. Now, this is a pivotal ruling by the Philippine Supreme Court because it extended the coverage of this protective writ. Now, going back to the question, I do think that, of course, judicial independence plays a very huge role in protecting minority rights. But on the other hand, there is also a need for improving access to justice in countries such as the Philippines, where there is a stark inequity when it comes to accessing justice and court mechanisms, for instance. There is an asymmetry, for instance, of knowledge about court processes and understanding about how justice is being done through these means. So I would say that it works both ways, that the courts as well as civil society both reinforce each other such that minority rights, and in my paper, indigenous rights, for instance, would be more protected.
Thank you. We'll take a question, please.
Hi, yeah. I have two questions, one for Ernest and one for you.
It's okay.
To
I'll try to be
Ernest,
short because I'll just 5 minutes.
in the Indian context, the Indian Supreme Court sort of in its own mind tried to strike a balance. And I think 2017, if I'm not wrong, it decriminalized same-sex relations. Again, there was a British era law on the books criminalizing same-sex relations. But later in another judgment, it refused to legalize same-sex marriage. The court was divided and they couldn't come to an agreement. And if you look at the argument in the later judgment, where it refused to legalize same-sex marriage, it basically said that we don't want to jump too high of the society. And that would probably make us irrelevant. That is the argument some of the judges were talking about. So how would you respond to something like that, especially considering what we said about Ghana in terms of where the society is? What could the Supreme Court have done, which could have sort of like pushed the larger societal consensus ahead? How would the judgment, if it had gone the other way, how would it have helped? That's my question for you. And for you, it's more like a comment which I want you to respond to. Like, we are in a very weird situation with respect to digital freedom of expression, especially in liberal democracy. Like some of the posts which the government would want the private platforms to moderate, even if they want, even if they want to take them down, they can't legally do it. So we have powerful governments hiding behind these moderation policies. Like this used to happen quite a bit when the Obama administration was in power. They would want Facebook to take something down, but they can't legally do it because there is this expansive understanding of freedom of expression where even misinformation, disinformation, conspiracy theories are sort of like put under political opinion, where you don't have the tools as a government to actually take them down. So the only recourse you have are the content moderation policy because it's a private platform. They don't have to follow or give constitutionally guaranteed rights to the users. But again, the other side of the problem is if you give those rights to the government, then you run the risk of empowering the government to take down political opinion. So how do you resolve this? Like,
okay. I know there's one more question. Do you want to ask your question so that we can try and answer all the questions?
Yeah, sorry.
We have those 3 more minutes.
But that 2 points that you mentioned also, I think are really strong in the 3 papers, and thank you for all of them. That one is in relation to liberal democracy. And I was thinking in the 3 cases, I don't know exactly how liberal the governments, the historical context were, but it seems as if to discuss human rights, these mechanisms somehow other certain groups and exclude them from human rights through, and it's interesting because it's through direct discourse in a way. It's not something that's kind of concealed. And Bembe was mentioned earlier in necropolitics, where you have, like a population that's excluded, but it's within the discourse that some groups are given rights and some are excluded. And it's kind of perceived as legitimate because it happened in this way. And I forget the other point, but
okay, so just before we proceed, we started like 5 minutes behind because people were grabbing lunch. So if you guys don't mind, we'll just take a few more minutes into your break to be able to respond to the questions.
Okay, so I'll respond. Good questions. So I think we take a lot of inspiration from the Indian case, the 377 case, striking it down, and the reasoning of the court. So I guess my simple or short answer to your question would be that maybe the Ghanaian court should have followed the Indian example. Decriminalize it first, because that's the barest minimum, and that is what we have been asking for in Ghana. So decriminalize it, and then that's it. You can criminalize identities, criminalize people's private lives and all that. But the court more or less was resorting to culture, custom, and other things, and not talking about the constitution at all, or constitutional rights, which the Indian court did very beautifully. Yes, I think I'll leave there.
Okay, cool. So that's an awesome question. And I agree with you, it's a dilemma. With liberal democracies, there's a wide spectrum of how people are approaching content moderation. In the US, they're very hands-on about it, and they just let companies do their thing. EU is stricter with their policies. The UK is somewhere in between. I could ask the corollary to your question, which is what happens when the government is posting content and the companies take them down? That could create a problem. Trump, in the last days of his last regime, he was suspended, and even in Nigeria at some point, Twitter was suspended because they deleted a post by the president, which they claimed was inciting, ethnic tensions, and the government suspended Twitter. So all these questions are worth considering. I think we should take the standpoint that it's an ongoing conversation, because even with the difference between print and broadcast media, for example, there's still debate ongoing about to what degree does the First Amendment, I'm talking about the US here, cover what broadcast media can, what's the word? Broadcast. So if someone goes on air and libels you, that station has to give you a right of reply. It has to, but that doesn't have to happen with the newspaper. And then so there are so many rules in that space. So if you think about that from there to digital space, it's an ongoing conversation. And so there's vigilance that has to, happen. We have to keep questioning and probing what is going on, and then the government really needs to invest more. This hands-off approach, let the companies do it, is really not the best. you know, in the end, they're really going to drive what suits them from a profit perspective. So I think it's an ongoing conversation, and there will be nuance here and there. Government has to play a more active role.
Yeah, just think the second point is exactly this. So sovereignty and human rights. Yeah, so if the platform, this was also the kind in those papers, if the companies have wield a sort of power that is sovereign-like, then they need to be accountable like
Exactly.
like a sovereign power, rather than, you know, treat them as private company or a business.
Yeah,
So that's significant.
I agree. Okay, so any other questions? Josiah, do you have any question? Any last words? I think you're mute.
Happy to be able to join online.
Okay, thank you. Okay, thank you very much, everybody, for your contribution.